Good afternoon. I'm your host, Brian Buckmire, here at the Law&Crime Trial Network. Now, we've got a few cases we're looking at. Now, before we get into the testimony of this witness, I want to introduce Michael Troiano and Francey Hakes. How are you doing today, guys?
Doing great.
Hi, Brian.
Thanks for having me.
Good.
Great. So we'll start with you, Francey. This is an interesting development where we're having a co-defendant who is not being tried at the same time. He's already serving his sentence, and he's giving testimony against the defendant. Eric, how did you feel that the testimony so far is going? I know it's been a mixed bag of results for a lot of people.
Yeah, Brian, it's so complicated when you have co-defendants testifying against each other. I think it's really hard for a jury, even if you've got one who's already been convicted. The jury has to wonder what his motivation is. Does he have a motivation to lie? Was he actually the killer? Is he pointing the finger at the actual killer? Is he trying to save himself on the back end somehow? But I just think it gets really complicated. But prosecutors have very little choice. You know, people just don't commit murders in front of choir boys and ministers. They commit murders either with each other or in front of no one. So you're sort of stuck with the eyewitnesses that you have.
Yeah, Michael, I mean, Francey's, I totally agree. She hit the nail on the head. Sometimes you don't get the choir boys, as she's saying, to testify. And as you can see in the screen there a few minutes ago, there are an assortment of co-defendants there. And so we have it that there's one co-defendant is testifying against the other. I mean, this is the definition of an interested witness. How do you, on either side, either as a defense attorney or prosecutor, kind of attack or help bolster this person's testimony?
Well, as far as the prosecution side is concerned, what they're essentially going to try to do is build up this credibility of the witness, if you will, and lay out that they are the only ones that can truly explain to the jury in detail what specifically happened, and that they're here to basically come clean and just, you know, have that so-called come to Jesus moment. Whereas from the defense's side, all you're looking at is attacking the credibility of the co-defendants, basically stating why they're doing this. They're getting some kind of plea deal that the prosecution is helping them out, and essentially tying this co-defendant's credibility to that of the prosecution and hopefully weakening it in front of the eyes of the jury.
Yeah, a come to Jesus moment would have been quite interesting for George Thomas to kind of approach this case, but let's take a listen to what he actually said. It sounded like he kind of minimized his role in this all. So a very interesting approach. Michael, first to you. When it comes to these proffers or having a witness who's a co-defendant testify, especially when you know there's a deal on the table for that person, he took a very interesting approach of kind of distancing himself from the commission of the crime, admitting that he was found guilty, but saying that, hey, this was not me. I mean, how are you to interpret that in terms of how it applies to Eric Boyd?
Well, it could be one of two things. A, he's trying to distance himself from the actual events, although he's already been found guilty by a jury in his previous case. And B, what we could look at is the fact that the prosecution, maybe I won't go as far as to say coached him, but explained to him that he needs to testify as to the differences between his actions, which he believes he was found guilty under co-conspirator liability and responsible for the actions of the direct principal actor in this case, and he was not the one that actually committed the rapes or fired the shots or sealed the young lady, the victim, in the bag and essentially executed them. And that's what he's trying to differentiate here for the jury in this specific case during his testimony.
Yeah. Now, we have Francey via phone, so we won't be able to see her. But Francey, a similar question. If this is what I would presume, maybe one of your, maybe not the star witness, but maybe quite close to it, I think you would want a witness to be able to say, hey, I admit that I did this, to kind of save some credibility, but really go harshly on what Eric Boyd did. I don't really hear a lot of that here.
No, in fact, Brian, he denied everything. He said very specifically that he didn't bind anybody, kidnap anybody, rape anybody, or murder anybody, really. And so he's saying he's not guilty at all, and therefore the co-defendant is. And even if he's telling the truth, it's going to be hard for a jury to countenance that when he's already been convicted. Co-conspirator liability is always a tough concept to explain to a jury. And when someone's testifying, they want an admission of guilt.
Yeah, it's going to be very interesting how they interpret it, especially as the defense attorney is going to attack the credibility of this witness based on the deal that they have. We're going to continue with this case and some of the readbacks and more after this break. So it's a very quick clip, but some of it is very powerful. Francey, when we're talking about inconsistencies, I mean, it's not just from a legal standpoint, it's also just from the day-to-day how we interact with people. You tell one story one moment, you tell another story the next. How powerful is that if you can really drive it home to the jury?
Yeah, it's really powerful, Brian. I mean, I've certainly seen you defense attorney types, you wonderful defense attorney types, stand up in closing arguments and list all the, quote, reasonable doubts. And inconsistent statements is a classic reasonable doubt claim by every good defense attorney I've ever faced. And so I think that those statements that were inconsistent are going to be listed, and they're going to be used to tell the jury, to try to convince the jury that you can't believe a word out of this co-defendant's mouth.
Yeah, I'm gonna one more question for you, Francey, especially because you have that background as a former prosecutor. I mean, stories change for different reasons. Maybe you remember things differently, you forget things. I mean, it doesn't necessarily mean you're lying. So how, as a former prosecutor, do you kind of overcome that hurdle and say, hey, I know they said one thing one day and then telling us slightly different. I mean, they're not saying it was Monday one day and Sunday the next, and it was black now and it's white now. They're just slight differences. How do you rehabilitate your witness when there are those inconsistencies?
Well, that's what you do. You try to rehabilitate them by pointing out that these inconsistencies, if they are insignificant. I'm not sure they're insignificant here. You're not talking about what color shirt was the female victim wearing. You're talking about whether or not this co-defendant participated in any of the violence, and he's denying it. So I think you've got to find corroboration, whether it's physical evidence or other testimony from other people or things that Boyd himself said. You have to find some corroboration so that you can redeem this witness's credibility. All
right, Michael, now to you, the defense attorney. I'm not sure about you, but pointing out inconsistencies in a witness is one of the reasons why I wake up in the morning. I mean, it's so much fun. Like, on the flip side, as a defense attorney, when you hear these, I'm assuming you've got to be salivating and you're just jumping at the bit to get at this witness.
Absolutely. This is the exact point of the cross-examination in most circumstances, especially when you have a co-defendant who's testifying against your client. And what you want to do is add up as many of those inconsistencies as possible, and in closing, not only harp on reasonable doubt to the jury, but explain to them, at least in Nevada, and I'm assuming in most jurisdictions, if a jury hears a witness on the stand and they make a material misrepresentation of a fact or a laundry list of facts, they are allowed to legally completely disregard their entire testimony as if they never even took the stand. And that's what the defense needs to do in this particular circumstance.
Yeah, exactly. It'd be big. I know in New York that's an often common jury instruction that's given. Now let's listen to George Thomas talking about his interaction with another co-defendant, Latavius, and how they're putting the blame all on Eric. So oftentimes we critique not only the style of the question, but how the question comes out. And Michael, first to you, sometimes you're not supposed to ask the question on cross-examination when you don't know the answer. But some of these questions are very interesting. You didn't care what happened to her when you did this in connection of placing the blame on Eric. I mean, however George Thomas answers, you're kind of winning, right?
Absolutely. As we stated previously, before we took the break, this particular witness is doing everything in his power to disassociate himself from the crimes and any of the actions, regardless of the fact that he was already convicted by a jury of his peers. And now what the defense attorney is attempting to do, and I believe he's doing successfully, is showing that this co-defendant who's testifying has sort of an attitude and no remorse for any of his actions. And not only would he commit the acts against the victims, but he would do anything within his power, including throw his own client under the bus in order to have a fair result and relieve him of any sort of pain or penalty.
Yeah. Now, Francey, you made a good point at the beginning of the segment talking about, hey, we don't have corroborated witnesses. There are not videos all over the place. So sometimes you're left with the witnesses you have. But as this witness is testifying, I mean, hindsight's 20/20. We can look over their shoulder and kind of judge them from the outside in. But did the prosecution kind of drop the ball by having this witness testify, the good friend of another co-defendant, placing the blame on someone they don't really know?
Yeah, Brian, that's a great point. And certainly that's something the defense will exploit. But as a prosecutor, you're stuck. If he's the best witness that you have because he has the most information, you've really got to put him up. And if you don't, the defense will drive a truck through that hole that you've just put in your case for why you didn't call that witness. And can I also just say that defense attorney is about as exciting as watching paint dry, but he's still making his point. You know, the lesson for attorneys is always on cross-examination, kind of make yourself the focus. You should be the one almost testifying. And here, the defense attorney is definitely not doing that, but I think he's still doing a more than adequate job of pointing out the inconsistencies and the character flaws of this witness in a way that does not bode well for the prosecution.
Yeah, it's an interesting tactic, and we'll see how successful it is at the end of the day. Let's now take a listen to more of George Thomas's testimony about how he didn't hear the rape in a very small house. So, Francey, it almost sounds like the advice that you were given just moments ago. The defense attorney is kind of enacting it now. He's starting at least slightly. It's maybe a little bit more entertaining than paint drying here. Maybe he's got a little bit more color in the paint. But he's starting to add his own little flair in terms of testifying. You didn't hear when she was being raped. You didn't hear when her lip was being ripped apart during the rape. Francey, it's making it seem like this witness is someone not to trust in his own senses.
Well, you're right, Brian. But also what's interesting about this is defense attorneys actually get put in prosecutor mode when they are cross-examining co-defendants like this. And this is the exact tact a prosecutor would take if a defendant was testifying, reminding the jury of the horrifying facts of the case in bite by bite. The danger here for the defense is that they're reminding the jury of the horrifying facts of this case bite by bite. So he's definitely taking a calculated risk in reminding the jury of those facts at the same time he's trying to make his point that this witness is not credible.
Yeah. Now, Michael, is this a risk worth taking? I mean, Francey's right. You're letting the allegations ring a second, a third, and maybe fourth or fifth time in the jury's ear, but you have this umbrella of it's ridiculous. If this had happened, you would have heard it. So is this the right risk to take?
It's certainly a risk, and I believe for these specific facts in this particular case, it's a risk worth taking. There's no dispute whatsoever that the jury is going to just brush off the horrific factual allegations of these murders. They're brutal, they're gruesome, and probably something that the jury's going to keep with them the rest of their lives. So in this particular matter, I think the defense attorney has the perfect approach, which is continue to bring out those facts, although it can lay on his own client, but at the same time put it at the feet of this co-defendant who clearly wants no responsibility and is not credible in the least to say that he didn't even hear these rapes and attacks going on in such a small home, in such a small area and location.
Yeah, and we're going to continue with the Eric Boyd case, both in recast, but also keeping our eye live for the trial going on after this break.